it's okay with me. I don't really want to be arrested. It's not a nice thing. And we'll talk about whether you really want to be arrested, I suppose. So what do you want to talk about? Do you have questions you would like to answer?
Why don't you start with presenting some stuff?
Okay, but it'll help me create a context, I think, if I know what you're interested in. I mean, if you don't have a question, I'm not asking you to think of one because I have plenty to say. But if you got a question you were hoping to have answered.
Well, I never know what the limits are. What gets you arrested?
Okay. Breaking the
how
law.
Far can you go?
Okay. Yeah. Did you have a question?
Yeah. Is it like technically illegal to, like, if our country is in war, to speak out against it? So it's wrong. I mean, who's saying got pulled before bumpers today? That seems strange.
That was one of the things I said in my email I might want to talk about, that speech is not free and you might risk arrest if your speech is effective. It's only really free if what you're saying is completely harmless to them.
Probably everyone here didn't see the email.
Oh, okay. So, all right. Let's start with the criminal law then.
What's your credentials?
What are my credentials? I'm a member. I don't actively practice law now, thank God. I got out of it by my own desire to do that. It took me probably about 7 years to get out of it. I think I would have had a stroke or a heart attack had I stayed in it. I don't really recommend that anybody get into it, although it is a position of power and authority. It will help you do good things if you want to do that. It's hard to make money at it, doing things that are useful and good. But it is, don't underestimate it. The knowledge that you gain is very useful. It will open your eyes, and it's very powerful. It's a position of power and authority. So if you want to manipulate power and authority, being a lawyer is a good thing to be. And for some reason, people are afraid of you when you're a lawyer because they don't understand the law. Probably lawyers have bad reputations, and they know that you can do things to them. You can manipulate power and authority. My credentials, I was a lawyer until last year. I'm still a member of the bar. I'm a member of the Illinois Bar, the District of Columbia Bar, and the Maryland Bar. I had a private practice in this town from 1983 through about a year ago. And I practiced criminal law, real estate, family law, and some other things. Did a lot of social, political, environmental things. Probably represented every student that was arrested here or had trouble with the disciplinary system and was involved in a left demonstration since the apartheid demonstrations. I think that's the first time I started working on those kinds of issues. And then after that, because I did them, except for the apartheid demonstrations, which were done mostly for free. I mean, I did them for nothing, so of course I was very popular. I think I was also very good at it, but I was very popular because I did it for free, and because you could call me at 5 o'clock, 10 minutes after you got arrested, and I would come down to the police station and yell pig at the police if they wouldn't let me talk to you. So people needed that kind of representation. Let's talk about speech a little bit, and then we can get into the criminal law and find out how it is that you get arrested and how you can try and avoid that. It's important to know what your speech rights are. It's especially important if you're going to exercise them at the University of Illinois, because the people who administer the University of Illinois, except for their attorneys, the people who administer the university don't know what the speech rights are, and that includes the police. It probably includes the police anywhere. They don't know what speech rights are. They don't know what your rights are, so they don't know what your limits are. And when they do know a couple things, they don't care. They'll arrest you when they want to arrest you, so that's part of the answer to your question. And I did send an email. It was a little bit of it was tongue-in-cheek, and a little bit of it was because I just read into Joe's message. I didn't even know what the context of it was, but read into it an issue that used to make me burn around here. It used to make me fume and mad. And that is that the university, through, what's her name, Yucky Llewellyn, maintains that you need a permit whenever you want to speak on the quad in a group of 2 or more. And it's absolutely false as far as the law goes. It's absolutely false. She's dead wrong. It's not the law. For example, during the Gulf War here, we used to have weekly protests outside the alma mater statue. And she maintained that we needed a permit to do that and wanted us to come and get one. And us, I mean, I'm sure there were many groups that were out there, but the group I was working with at the time. And we said no, and she went away because she had no way to force us to do that. She's not going to take you to court. She's not going to arrest you, or the police aren't going to come out and arrest you because you don't have a permit. So when do you need a permit and when don't you need a permit? And what are speech rights a function of? Speech rights are a function of what are called forums. Forum is a technical term, it's a legal term, it's a term of art, and it's a term a court would use to reach a conclusion about whether you had a right to speak in a certain area if you were arrested. And there are basically three types of forums. There are public forums, there are semi-public forums, and there are private forums. The classic example, and if the court would determine that you were in a public forum and some other things, like you weren't interfering with anybody else's right to use the forum, then your right to speak is free. You don't need a permit, period. You don't need a permit. You might need a permit if you want a microphone and they've got the electricity, right? That's a reason to go get a permit because they've got facilities that you want to use and they can lawfully ask you to get a permit there. But if you're a preacher and you want to go out in the quad and try and convert people and you attract a crowd of 50 people, 2 o'clock in the afternoon on a nice day when the windows are open and they can hear you from classrooms, you don't need a permit as long as you don't speak loud enough to disturb the class, right? Somebody else's right to use the forum. So what's the quad? Is it a public forum, a semi-public forum, or a private forum? All right, let me step back. So if the court would conclude that it's a public forum, you have a right to speak, you don't need a permit, you can speak in groups, you can have a march, you can have a demonstration, you can do whatever, as long as you don't interfere with the rest of the forum. If the court would conclude that it's a private forum, you don't have a right to speak unless it's granted to you by the owner of the forum. So you can't, for example, the typical example of a private forum is a shopping center. You can't go into Lincoln Square, you can't go out to Marketplace Mall and distribute leaflets because that's private property. If the mall lets you do that, fine, but if you go in and do that, you can be arrested. And the way you would get arrested is they'll tell you to leave, and if you don't, well, then you don't have any more permission to be there. So you'd be trespassing, and the police would come and arrest you for trespassing. And a semi-public forum, that's a sleaze factor in the law, and the court probably reaches the conclusion that it's a semi-public forum when it doesn't know exactly what to do, and it really wants to make some policy about how speech rights should be interpreted in that forum. One thing you have to understand about the law, there's an illusion that people have about the law. And the illusion is that the law is a system of rules that some judge knows and that she or he applies as though it were some kind of mechanical formula. You know, oh, you did this, the rule is this, therefore, whatever. And the law isn't like that at all. That's the illusion of law. That's what makes people think the law is impartial, but it's not like that at all. That's also false, patently false. Courts are policy-making bodies, and they make policy as much as legislatures do. They just make it in a different way. So when you're talking about constitutional law and you hear all this talk about the intent of the framers from the far right, and the Constitution should only be interpreted to implement the intent of the framers, as though the framers could ever think about something 200 years in the future. That's smoke and mirrors. What they really are saying is they want a certain policy implemented. And it's very obvious when you do constitutional law, for example, when you would do speech rights, that when the court concludes that you have a speech right, it's setting a policy about the distribution of rights in the society. And it's as though it's making law all over again. And in fact, when cases get decided, law is made all over again. Legal reasoning is not deductive. It's not from a major premise and a minor premise to a conclusion. It doesn't work like, it's not like mathematics. Or it's not inductive. It's not from this instance and this instance and this instance to another. The reasoning is by analogy. It's this happened before and we decided this way. And here we have a set of facts that's kind of like this, but not exactly. And it's significantly like those facts and significantly different, and therefore this will be the policy now. that's what happens. And constitutional law is a perfect example of it. It's very difficult to understand for that reason. So what's the quad? The quad is probably a public forum. It might be a semi-public forum. And the quad, and this is why Yuki is so dangerous. The quad is actually what you're going to make the quad be. Because something is a public forum or not by its very nature, but really by how it gets used, historically how it gets used. At least something like the quad is. And historically, the quad has been open to speech without permit. And that historical fact is very important. There was a period of time where I used to cut out newspaper articles when some speech event would happen on the quad, and it was obvious that people didn't have a permit. And I would save those because I knew if I ever had to raise a speech defense about something on the quad, I would want to be able to show through those articles that the history of usage was without a permit. And that when Yuki would come out and tell us we had to get a permit is because she wanted to keep an eye on us and nothing else. And that's all it was. And that she was really trying to exercise a prior restraint over us. And she would go so far as to want to know, before she'd grant the permit, she'd want to know who the speakers were going to be and what they were going to say and who the people were going to be that came to listen to them. And this was absolutely outrageous, and the kind of transparent justification she gave for it sometimes was that she had some advertising dollars that she could spend, and she wanted to do some direct marketing or something with it and spend it effectively so she could help us get people to our event. Man. Anyway, she's dangerous from that point of view. She's lawless the way most of the administrators over there. They don't respect the law because they don't have any knowledge of it, and if they do, they don't really care. And you have, and at some point, I would urge you to do things out there without a permit, simply to maintain that historical integrity of the forum. And other groups do it. I don't know. Does Take Back the Night still happen? Mm-hmm. Yeah. So those people don't get permits. They just start marching, and in fact, they march through the Union. Right? And I'm sure that's illegal with their signs and everything. I mean, but they're in such mass and number and angry and intent, and the issue is so volatile that the police aren't going to arrest them. It's easier just to let them go. But you need to. I would think you need to keep a certain tension with Yuki. You need to maintain that historical integrity, because if you don't, you're going to lose the right.
There was this guy, Rose, did you know the story? The guy that got arrested?
The
guy that thinks he's part of our...
He didn't get arrested.
He didn't get arrested. They asked him for leave though. But he was in front of the alma mater, and I think he had tape, or he had shirts on it. This guy that he's just kind of whacked out, and he thinks he's part of our... And but the police didn't come, right? And take him there.
What was he doing?
There's a restraining order against him being on the campus at all.
Oh, that's what it
He's
is.
threatened living on the campus. He's lost a job. So
Okay.
he shouldn't be here
Anyway.
at all.
Okay.
He just had signs and things taped to the alma mater.
Yeah, and I mean, look at the factual difference too. I mean, now you're doing something with property, you got something taped on it, you're selling a product, you're vending, that's commercial speech. Maybe commercial speech doesn't have as much protection as political speech.
My question is, when you're talking about the quad, you're just talking about the outside, correct?
Correct.
You're not talking about the buildings, because
That's
I
right.
guess when you started talking about the quad, I'm thinking public institution, public lands, and of course you know everything that happened with,
Right.
The arrest of the anti-apartheid arrest, but I mean, does something significantly change when you walk from the outside to the inside of the building?
Yes.
Whether or not you're touching anything, or you're not,
Yes.
destroying anything.
Yes. It does change significantly. It's the outside, it's the open area. Although inside, enclosed areas, one of the best cases to come along recently, which made me rethink what you could do in the assembly hall without a permit, was a case that involved the Nassau Coliseum. And the Nassau Coliseum is on Long Island in Nassau County. It's a huge building, bigger than the assembly hall, where sporting events take place. So I guess whatever hockey team plays on Long Island plays out there, and probably some basketball stuff and other events. And they, as a matter of history in that building, would allow people to come in and hand stuff out. And so sooner or later, some religious group came in, Hare Krishna, or I don't know who they were, it doesn't matter. And they were handing things out, but they were offensive to whoever was controlling the building and the police. And so they kicked them out, and they got arrested, and they raised as a defense the speech issue, and won by showing historically how the building had been used. So it made me rethink of I was wondering, what goes on in the assembly hall? Do they, during basketball games, do they let people come in there and hand stuff out if it's of a certain type of, a certain type of literature? When Lou Henson was, when Lou Henson retired last year, I was listening to WDWS, and what's his name? Turpin. They wanted everybody to bring banners, right? They wanted, yay Lou, bye Lou, was great, So I called up and I said, hey man, I'm coming and I'm gonna bring an anti-chief banner. And I said, well, you can't do that, it's only Lou banners. And then someone called from the university, hey, he can't do that, it's only Lou banners, right? And I called and I said, but you let one banner in, you're letting all the banners in, right? You establish that kind of practice. You can't keep me out because I'm going to say one thing you don't like. This is the state. So they called the whole thing off, apparently. But the point I'm trying to illustrate is the practice that is actually allowed determines what your rights are. And I mean, that's a bad example as far as history goes, but because I was concentrating on the historical part of the plot. But if, for example, you start seeing them do something like that at the Assembly Hall or another building that you would like to go into and kind of push the limit a little bit, you can plan your defense, in other words.
Well, in the anti-apartheid stuff, we were focusing on the board of trustees when they still got elected, going to one of their election things. It was in Springfield at a union hall. And some of our members had credentials, got in, had signs that were made with poster board that said divest now, stuff like that. And they threw them out and said they couldn't have signs in there.
Private forum, union hall.
This was an electoral thing. There were signs everywhere. Vote Democratic, vote this. Everybody had signs.
But if it's a union and a union hall, I mean, they can keep stuff. I mean, that's a private organization.
They can decide what they want.
Yeah, they can decide what they want to show.
But they said no signs were allowed. We're like, every person in there had a sign. It's just our signs were different.
The main difference between what you're describing and the situation here is that that's a private organization, and this is the state of Illinois. And constitutional rights protect the people against the state. The first 10 amendments, where your rights come from, on their face, protect the people against the federal government only. And in fact, I think in the beginning, in the early years of the federal system that we have, there were some states that had established religions. And it wasn't a violation of the First Amendment for a state to establish a religion, because the first 10 amendments don't get applied against the state historically until the 14th Amendment is passed as a result of the Civil War. And it's part of what was won in the Civil War was protection against state abuses of the people. And one by one, these amendments get incorporated into the 14th Amendment and applied against the states. So the First Amendment applies against actions of the state of Illinois, but not a union organized. There's no constitution.
It was the Democratic Party was supposed to lead that.
Still, I don't, that's a private organization. I don't think you wouldn't have any speech right. You might have an organizational right of some sort. Yes.
Okay, so we can't bring signs to a union. Is that the deal? Because we had a talk in the Courtyard Cafe the other day, and like 8 Republicans came in and had signs.
Oh, they did?
Pro-chief stuff. And they didn't get kicked out.
Did anybody get any pictures of that stuff?
Yeah.
Save, boy, when you see those pictures, cut them out and save them, because part of the way, I mean, one of the arrest stories here with the PRC is an anti-CIA demonstration in the union with signs, and they who was that person that runs the union? Susan Mall comes and says there's a rule about not having signs in the union, and of course when is that where you got your name? Your nickname?
No, that was true.
All right. When I can't call him that yet. When Jeff when Jeff asked Susan, show me the rule, politely.
No, I didn't ask you, I asked the cop.
Oh, ask the cop. Well, yeah.
Show me the rule.
Well, nobody could produce a rule. And can anybody guess why?
Doesn't
There isn't
exist.
one.
Let me just give some
They make
context.
them up.
What happened? We were out. The board of trustees meets in that president's lounge. The union's a lot different now than it was then, but part of the north part where there was a ticket counter stuff. And we were just in the hallway walking around, 10 people with signs. So we had 3 people inside, and all of a sudden they came. They grabbed the 3 biggest guys and they arrested them.
Yeah, well, they grabbed him as they were walking out.
And we were leaving.
Yeah, Jeff had given them.
I was the one yelling at the cop.
Oh.
He didn't arrest me, but.
Yeah, well, it was safe to grab these guys, right? Their last 3 couldn't be protected one by one. And they were leaving after the union orders to leave. So.
And they couldn't figure out what the.
Another answer to your question, how do you get arrested? Well, sometimes you do it by not leaving the shopping center when they tell you and you're trespassing. And sometimes you just like walk it and they grab you and arrest you. So it's not completely predictable, and that's part of what you have to understand. It's one thing to plan civil disobedience and to be prepared, when people are arrested to do this, that, or the other thing. It's another thing to have a demonstration and to be actually complying with the directives of the police and leaving the building and simply be arrested and you don't have any plans about what to do. So I think, and Jeff mentioned to me, this is something we should talk about. It is something we should talk about because it's quite possible to get arrested when you're obeying the law completely because the police don't understand the law, and sometimes when they do understand it, they don't care about it. They just arrest you. It's just kind of like a raw, naked exercise of power. They arrest you. So you have to know what to do. So let's jump from. Well, before we leave speech, is it a little clearer maybe what free speech means and what it's not? You're like snickering. No.
Oh, no, I was just looking at her because her hand was going up.
Well, it seems that everything is pretty soft and up to interpretation. But I have a specific question. What if, when the fascists are going to have their rally the day after we do, in one end of the quad, what if we have a drumming circle at the other end of the quad? Is that interference?
Great question. No, I mean, no, it's no more interference than it is them yelling at you 10 feet away when you're having a rally. It's them standing on those concrete benches along the quad, and you're in the free speech area, and you have your microphone, and there's 10 of them chanting or something like that, or yelling at you. No, I don't think it is. You don't need a permit to go down and do that. You just gather it and you do it. If you did it and it was so loud that it kept them from being heard, well, yeah, that's an interference. That's not fair. And if you disturb, I would think the real thing to worry about is whether you interfere with a class. Because the courts will protect the function of the university, which the courts perceive to be to educate people through classes. So if you interfere with the university's rights and ability to put on classes, you're in trouble. You won't have any speech rights.
But they can maintain that regardless. They can just say, oh.
They have to prove it, right? They have to prove it. I mean, sure they could maintain it.
They said
but
the shantytowns were disrupted.
Ultimately, they have to prove it. Although, interestingly enough, probably the banter back and forth, there probably is a legal distinction between, the fascists up there having their rally, and you being with drums and drumming loud enough so that they can't be heard. There's a distinction between doing that and getting inside their rally and arguing with them so intensely that they can't effectively hold a rally. That is probably protected. The drumming isn't. And the reason that argument is probably protected is because the court thinks about speech in terms of a marketplace. And the court, this is all fictional, but the court doesn't want to interfere and regulate speech because it wants the marketplace of ideas to do that. So if just like you might picket somebody selling dangerous lawnmowers or not buy their product or go in and argue with them about their lawnmower, you can get face-to-face with somebody and argue with them about their ideas. That's the marketplace, right? And you could build a good defense on that, but it'd be rougher to build a defense on the drums, unless the drums had some kind of symbolic value. theater is protected.
This kind of takes it into a different area, but on the free speech stuff, two examples I'll throw out. One, during the anti-CIA stuff, which is kind of a complex issue, we were arguing that the CIA should not be allowed to speak on campuses because they were recruiting to an illegal agency. We were accused of violating free speech.
Yeah. This is a bizarre one.
So maybe, now let me just answer both of them. The KKK is active at Fisher again, right around here. I don't know if you've heard of the CIA.
I saw an email. Somebody sent an email.
They're probably going to. They're saying they're going to hold a rally. Yeah, it was in the paper. They're talking about having a rally. So we may have one of our ideas actually to get them to be pro-chief. That'll help.
Yeah, that'd be great, wouldn't it?
But
I got the name. But he's in Indiana.
anyway,
Butler, Indiana.
so okay. Now we have the CIA as one issue. We're saying that recruiters should not be allowed on campus to recruit for this thing, and then we're accused of violating free speech because we're trying to stifle their right to speak. Now, if we go to the KKK thing and try and disrupt that, there's two different issues here. Go with them.
Okay, well, the government, does the government have speech rights? Does the state of Illinois, could the state of Illinois, here, I'll give you a context for it. Does the state of Illinois have, do the administrators of the university acting as agents of the state of Illinois, engaging in state activity, do they have a First Amendment right to portray Native Americans in the form of Chief Alina Webb? Is there a protected speech right in the university to do that? I don't know. I've entertained that question before. It's come up before, and I haven't looked at any authority on it, but I would think the answer is no. And I would think the answer is no because the First Amendment protects the people against the state, not the state against the people. Now, President Stunkel, in his private capacity as an individual, could speak about the chief and could speak in favor of it, and he would be protected in that capacity. But in his capacity as the president of the university, in official actions of the university, which is right, the flagship of the state of Illinois, flagship educational institution, has no speech right to do it. It doesn't mean he can't do it, doesn't mean he won't do it, just means that he couldn't defend, for example, some suit to dismiss the chief by claiming it infringes his First Amendment rights or infringes the university's First Amendment rights. The university doesn't have First Amendment rights. That sounds weird, doesn't it? Something's wrong with it. At least it doesn't have them against the people. It has them, obviously, to engage in the pursuit of knowledge, and this is a university, right? So it's like full of First Amendment rights. But it doesn't have them as a protection against the people, which is the way you'd have to construe the issue. Maybe this is wrong.
Bryan,
Yeah.
on that point, because this may be an issue we have to deal with, hasn't it happened that corporations have rights as individuals, and doesn't that, haven't there been cases like, I don't know, maybe the tobacco cases and stuff like that, where corporations have claimed free speech rights based on their status as individuals coming out of prison?
Yeah, usually with corporations, it's going to be a commercial speech case. It's going to be...
So the university would be considered a corporation?
Well, it would be, but it's, again, the difference between R.J. Reynolds and the university is that R.J. Reynolds is owned privately, and the university is part of the state of Illinois. So it's, again, and that's where your rights really, that's why if you were engaged in this kind of activity at George Washington University in the District of Columbia, whereas Bradley's a private school, at Bradley University in Peoria, you couldn't invoke the Constitution to protect you. Why not? Because Bradley's a private institution. George Washington is a private institution. R.J. Reynolds is a private institution. So you can't invoke a constitutional protection. Now, if the police hired by Bradley arrest you, and in doing that, they violate your First Amendment rights, you can invoke it there, but that's because police authority is state authority. It's a state function now being implemented by a private group. So the distinction is always some way between the state and a private individual. And it sounds really weird to me to say the state doesn't have First Amendment rights, especially when it's a university, because you get all this educational stuff going on. With the CIA, the question could be, nobody has, of course, a right to break the law and murder, or to engage in violations of the Nuremberg principles or other human rights acts. So when the CIA plots the assassination of some foreign dictator, whoever it is, I mean, no matter who they are, they're of course, they can't claim First Amendment rights to protect them from us finding out about it. Because
but what happened?
But they do.
Remember what happened was that the right-wingers would accuse us, even some of the liberals would
Terry
accuse
Shepard did. The universities.
Yeah, would accuse us of stifling free speech by saying that they should not be allowed to recruit on this campus.
Right. Yeah. Well, that's just a bogus argument. That's as if the CIA could invoke the First Amendment to protect its right to break the law internationally and commit murder and overthrow governments. And it's just nuts. That's just stupid.
So
it's not thinking.
So what would a response to that be when somebody said
stupid.
to you that you are?
No, it wouldn't be. No,
No, but I mean, somebody's gonna, because I can see the gears turning in someone's head if they're reading the Daily Illini and it says, protesters trying to stifle the right to free speech of the CIA or the right to free speech of pro-chief, administrators or whatever. And so we would need to couch a response.
Okay. I would couch the response. I mean, you can make a judgment about whether an attempt to educate the person saying it would be successful. And if you think the person is open to reason, could be educated, then you would explain to them that the CIA is engaged in criminal activity. It's an organized criminal enterprise. It's in violation of federal and state and international law and cannot invoke the law to protect itself against its crimes. That would be the rational response. And if they're not listening and they just blabber on and they don't really want to learn, they're stupid, you can tell them that and move on.
I guess what I'm just saying is,
this is why you would never let me say anything.
But can you just say to them, it's an institution, it's not an individual, it's an institution, and that it's a federal institution, a governmental institution, and governmental institution does not have the right.
Well, yeah, I mean, there's that kind of, that's a real abstract argument. I think the better argument with the CIA is that they are an organized criminal enterprise. Although they exist in our political system, they exist only because the political system is above the law, and it is somehow not subject to the constraint of the law, because we all know they are an organized criminal enterprise. They do violate the law. They violate our constitutional law, our federal law, international conventions, federal law that comes from international law, like Nuremberg. I mean, they are engaged in criminal activities, and they get away with it.
What we used to argue is that if they want to come and speak, that's fine. But they weren't speaking; they were recruiting.
Yeah, recruiting people to murder.
They were engaged, and that was not a right.
No, nobody has a
privilege.
right.
The university was given the privilege to get people in their institution. We say, like, well, would the mafia be allowed?
Right, exactly.
To
No.
do recruiting at the U of I.
And why wouldn't the mafia be allowed? Because the mafia is a criminal enterprise. I mean, I think the better argument for the CIA is that it's a criminal enterprise. And so, I mean, maybe you could apply that argument against the university if it tries to protect the chief. And that can't be protected speech because it's, of course, racial speech is protected, isn't it? I mean, the speech of the Klan is protected.
So the Klan. So Klan has a big demonstration. What are we allowed to do legally? Protest of it. And this happens all over the place.
You're allowed to engage in the marketplace. So you're whatever the people governing the marketplace set that out to be. The court now is going to, because of the potential for violence, is going to allow the police to place constraints about how close you can get to them, where they can be, maybe rope it off, and so on and so forth. But you can engage in, heated name calling, which is what they deserve.
What about harassment? Aren't there laws against harassment? Can't you say, well, the KKK is obviously harassing people by doing this? They're stepping over First Amendment into harassment. You know what I mean?
There's no law that I'm aware of, which puts out a legal category called harassment. Racial intimidation. I'd have to look at the statutes because I'm not really current on it. You can't incite people to riot. You can't incite people to violence, and if your speech is meant to do that, it can be restricted and prohibited. Of course, that's a very dangerous rule, and really was used against points of view that you would be advocating more than the KKK, and it's used probably against anti-war demonstrators more than it's used against the KKK. You know, and if we can the best solution would be a political solution, and you know, in a sense, I get suckered into this marketplace analogy. The best solution would be in the marketplace. It would be, you know, just as you put a dangerous product out of consumption by a consumer, you put a dangerous idea out of consumption by people who are new and learning ideas. The trouble is that it requires people to be rational, and the whole thing assumes that people are rational and that the bargaining power in the marketplace is equal. And of course the government steps in and regulates the commercial marketplace, because if it doesn't, the disproportionate bargaining power is so great that you know, we would have even less of an environment left, we'd be having dangerous products, we'd be ripped off by fraudulent commercial transactions. So the government regulates that stuff. So it regulates your speech too. Yes?
I was going to ask about the Board of Trustees, because I mean, it is in buildings, so it's not out in the, you know, the public or anything. But do they have the right not to have us address them when
They're
any
so
other
tight.
speaker can address them? I mean, there's so many things that are thinking about the legal system, specifically that. Do they have the right not to answer our questions?
Yeah, they do have the right not to answer your questions. They have the right to conduct their business in the manner they see fit to do that. They do not have to entertain your questions. There was some. I am absolutely shocked that they let you come and talk to them. They wouldn't do that for a whole year when they first announced the rule. What really bugs me about the board, and I mean this would be a dangerous protest, but it would be so funny if you could do it. Have you ever seen a legislature in action? Have you ever seen the Illinois legislature? The place is noisy as you can imagine. They're not paying attention to anything down there, just talking and talking and talking. There's all kinds of noise. The galleries, they're all talking. I mean, the sound level in there is almost deafening. And they get their business done, right? Or if you've ever watched the English Parliament, there's boos and hisses and nays and, you know, you pig and, you know, the Queen is whatever, and they get their business done. And the bot, man, you gotta be as cool. You have to hear a pin drop in there for them to conduct their business. And who almost got arrested for laughing too loud? Was, what's his name? I can't. Yeah, Jeff Boyd. He was laughing as a form of protest at things they say. What's his name? Came over and told him to shut up. The big Doble.
They're both fine.
The guy from Star Trek. So you know, you might go in there. You know, and I think the defense here would be they accept applause, right? They accept some nonverbal speech as appropriate. Well, if they accept applause, they should also accept boos, because if they don't accept boos and they do accept applauses, they're really being censors. They can't say you can only speak when you agree with us. If they're going to say you can speak through applause, they have to say you can speak through boos, because otherwise they're censoring you. And I think that if the trouble is not really with the courts here, is if you got arrested for booing at a board or laughing too loud at a board of trustee meeting, I think the judges, I think you wouldn't have any trouble getting out of a criminal charge that might be lodged against you. The real trouble would be with the university disciplinary system.
Good segue.
Good segue, yeah. So let's talk about being arrested.
Let me throw two scenarios out, and you can talk about the levels of what would happen.
Okay.
So I'm going to throw three out. Maybe you can respond.
Okay.
So we're on the quad, having a demonstration, moving around. For some reason, somebody gets grabbed by the cops and gets arrested. Second scenario, the board of trustees meeting. Start chanting and begin to leave, but they grab and arrest us. Third scenario is that we're at a KKK rally in downtown Fishman,
Get shot.
and we cross a line that we didn't know about, and we get arrested. So what are both the state and disciplinary responses to those scenarios?
Okay, let's talk about the quad and no apparent reason for an arrest.
And these things have happened before. I mean,
Yeah,
happened in
sure
the
they've
60s.
happened. When you get arrested, if you get arrested, suppose they just grab you, okay, and you know it's a police officer grabbing you. The worst possible thing you can do is pull away, or resist in any way whatsoever, go limp, or
Knock their cap off.
or knock their cap off,
That's what
or
happened
grab
that
their
one.
gun. Any kind of pulling back, any kind of resistance, because what you've just done is you've created you've created a charge that will stick, whereas you might have just had a charge which you could have gotten out of, and in fact turned around and sued them for damages for. So if they arrest you for no good reason, you might ultimately be able to show that. But if even if the arrest is unlawful, if you resisted, that's resisting arrest, and it's not a good defense now to say that the initial arrest was unlawful. In Illinois, it used to be a good defense to say that the initial arrest was unlawful. But until that real tall kid, Chief Justice, what was the name of that guy? My mind is just going dead. He got in trouble with the police for getting caught driving drunk, and he got out.
Oh, yeah,
These are Heupel's decisions, right? Heupel, who complains about how the police treated him so roughly, is the one who authors these terrible decisions about resisting the police. They're good Illinois law. You cannot resist the police. So whether you plan to be arrested or not, if you get grabbed and arrested, don't resist. Now, it's a little different if someone grabs you and you don't know who they are, right? Then it's a natural reaction to resist, and it might be in your best, it might be some crazy person.
or you mean if it's a plain clothes cop or something? You don't know who they
Yeah,
are?
you don't know who they are. If someone, you would normally react by pulling away or shoving or whatever if some stranger grabs you, right? You don't want to, and that's protected. But if it's a police officer, don't do that. And if you get to the station, don't refuse to give them your name, or don't give them a false name, or don't refuse to give them any of the other booking information, because then it will be interfering with the lawful duty of a police officer. And that'll be a charge that sticks, even if the original charge is not a good one. And you might want to have something, I was thinking about this, you might want to all execute affidavits that those of you who weren't arrested could bring to the police, and the affidavits would say, in case I'm arrested, I authorize Jeff to get so-and-so as my lawyer to come and talk to me at the police station.
That problem.
Because even though friends, there were some kids arrested on Green Street, and their friends came and got me, and I went to the Champaign police station to talk to the police, and the police said, this guy's parents, this guy didn't hire you, and his parents didn't hire you, therefore you can't talk to him, even though the state has a statute which allows you to communicate with an attorney after you're arrested. And this guy didn't know who I was, and they wouldn't let him talk to his friends. So this guy couldn't call me, didn't know who I was, he couldn't communicate with his friends. His friends had gotten a hold of me, but now they won't let me talk to him. That was when I called him a pig. And so you might, to avoid that kind of thing, you might want to have some official document that says, I authorize, Jeff to hire an attorney for me, or whoever you're going to designate.
You just have that notarized, or what makes it?
Yeah, an affidavit. An affidavit is a sworn statement, so it's, you swear to the truth of this, I am so-and-so, I'm engaging in, political speech, if I'm arrested, and I don't intend to be arrested, but if I am, I authorize Jeff to do whatever. And then Jeff could show that to the police.
Do you have to have a notarized or something like that? Or
If it's an affidavit, you do. That's right, just go to a notary.
Well, explain now, what happens if you're arrested by a university cop? What's the process? And then
Well, they book you, which is a process of gathering information about who you are and where you live and what your telephone number is. And give them all that information. Do not engage in small talk with them. Don't talk to them. I don't care what they're saying to you. You give them the booking information, but you don't tell them anything about what happened. And the way is they're not your friends, and they're liars, and they try and get information out of you, and they try and use that information to convict you, And if you talk to them and give them any kind of information, they're going to distort it, and the courts are going to believe it because the courts don't believe it through this lie. So, and the way they usually get the information is to engage in small talk with you. So don't engage in small talk.
But how come we differentiate the things that we should answer?
Well, because they'll be sitting down at a typewriter and taking the information. You know, I mean, there'll be stuff. You just use your common sense. It'll be stuff like, you know, what's your name, where do you work, what's your phone number, as opposed to what were you doing out there, you know, who were you with, you know, what did you say?
Is it essentially like name, rank, and serial number? That's what
Yeah,
you have to do.
yeah, it's identifying information.
But what I was doing, who I was with, I had to answer those questions?
No, you don't. That's
Oh.
stuff you don't have to answer. And that's the way you would, I mean, would that be a common sense distinction you would make?
Mhm.
Yeah, use your common sense. You'll be a good guy.
So what would you say to them though if they say, you know, what would you do? I mean, what's your response? You just ignore it and say, I'm not
Yeah,
going to.
I don't want to talk. Yeah, tell them I do not want, except for booking information, I do not wish to speak to you until I have a lawyer. That's what you should tell them. Tell them that politely. You don't have to be angry with them, right? Cooperate with them. Because if you don't, you're going to be in worse trouble, and you'll ruin your defense. And that's the kind of situation where you're, and that's what I would recommend in a planned arrest and an unplanned arrest. Now, sometimes people who demonstrate and plan to be arrested do things like go limp. Right? I mean, that's a kind of protest. The abortion protesters did that at the clinic. You know, made the police carry them out on stretchers. Of course, if they had been if they had been a left protest as opposed to a right protest, it wouldn't have been stretchers you were taken out of. You would have been dragged out and by people without badges on. I mean, that's the difference in the way you're going to get treated. But you know, things like resisting arrest and interfering with the lawful duties of a police officer, those are you can't get a certain type of disposition in the resolution of a charge. You know, ultimately you're going to wind up before an arraignment court, in a court where a judge explains.
Go through the process. So you're in the jail.
So you're in the jail, and then you have a.
We're in university jail now, right?
Right. You're in the university jail. They probably will transport you to Champaign County Jail if it's serious enough. If not, they may let you out, and they may let you out. They're going to let you out only on some type of bail, and bail is security that you'll return. Bail can be as simple as your promise. Your promise has value, so it's security. Your promise to return upon a notice to show up in court, or it could be something like cash. And if there's any property damage or violence or disruption of a major university event or combat with the police, there's going to be cash involved. So you want to have some money set aside. And you'll get a notice to appear in court, and the first appearance will be at an arraignment court. At an arraignment court, the court's function is to explain the charges against you.
You're talking the state level now.
Yeah, now you're at the state. You're at the circuit court in Champaign County. And you're being arraigned. In other words, there's a judge explaining to you what the charges are against you, what the possible penalties are. The court's going to ascertain whether you have an attorney. If you have an attorney, whether you want to plead guilty or not, and whether you want a jury trial or not. If you don't have an attorney in this county, even though you could represent yourself, you'd be crazy to do that, and the court knows that, so it really urges you to get an attorney and will continue the arraignment to another hearing. You really don't want that to happen if you can avoid it, because it's another time you have to go to court, and there's a lot of energy involved in getting a group of people together to a court. I mean, the organizational energy you'll have to put in now, simply because someone's been arrested, is going to be almost overwhelming. You always, if you ever get an attorney who tells you to plead guilty or don't have a jury trial or anything like that, get rid of the person. You always plead not guilty. You always request a jury trial. If you don't request a jury trial at an arraignment, you will waive your right to have one. You have a right to a jury trial, you have a right to consult with an attorney, you have a right to remain silent, you have a right to be presumed innocent, you have a right to bail, reasonable bail, you have a right to medical treatment in the institution, and so on and so forth. You have a right to humane treatment, which is
Where are all these rights listed? How do we know?
They're listed in the statutes. They're in the alma mater statute. They're in the statutes, and they're common sense. I mean, you'd know what these things are just from watching TV or listening to the news. They're all common. We grow up with this conception of justice, so you know what they are already.
So we're at the arraignment.
Okay, so the state's attorney's office is now run by a person who's a protege of Tim Johnson. Does everybody know who Tim Johnson is?
No.
Tim Johnson is reborn. He is right-wing. He is the master politician of the political party in Champaign County, and he is responsible for several of the judges sitting on the bench and for the state's attorney. The state's attorney is reborn, and his political views, he believes we should have dropped more atomic bombs on Japan and maybe some on Russia. So this is where this guy is coming from. And he is real hard on drugs and real hard on police, any confrontation with the police. So this guy is going to be trouble unless you can raise a good defense. No, we're talking about, what's his name? I can't remember his name.
Started off with Tim Johnson.
Yeah, Tim Johnson. Who? Pilot, John Pilot. Oh, that's right. Okay. DeFanis used to be the state's attorney. He's also reborn. Now he sits on the bench. He was when what's his name ran for the president, that preacher. He was a Pat Robertson delegate to the Republican.
These are all your personal friends, too.
These are my personal friends. Just drop my name. Now.
And the bail will go up.
Now, I'm gonna bring up a potentially touchy situation from the email that I read. One of your best chances at winning a defense, especially in a planned arrest, is a guy named Francis Boyle. Now, I know there's been some tension in the email with Francis, because Francis appears sometime to be unusual. And but I think you can see from the letters that he's generated on the chief issue, and from the broad range of people that he's able to contact and get support from, that he's an interesting person at very least. He's also a person who developed and kind of marketed in the intellectual legal journals a necessity defense for protesters. He's successfully defended people who have cut down the ELF towers in Wisconsin, those towers that are used to communicate with submarines. I mean, people who have engaged in what the government would call treasonous acts. He's successfully gotten some of them off completely, charges reduced from mandatory, X years in prison felonies to misdemeanors. He knows how to set up a defense for political resistance.
But he can't actually practice law.
He won't be representing you, but he's an expert witness. He comes in and testifies, for example, in the cases where people were protesting nuclear war resistance. People who were protesting the possibility of nuclear war would do things like destroy government property by cutting down these towers, or by slamming sledgehammers on the missile silos, or whatever they were doing. He would come in and talk about the law of war and the law that restricts war, and basically Nuremberg, and why it's unlawful under our federal law. Under our federal law, to wantonly destroy cities or to engage in acts that violate human rights.
But Brian, they would never let Francis testify. During anti-apartheid, it's even more right-wing now than it was then.
Well,
and they have to allow us to use them.
Well, that's right. The plan would be to change the venue. The plan would try and be to get the thing up to Chicago. Well, yeah, I mean, plan on spending some money if you're going to do it. The reality of arrest, if it's planned, I mean, we've kind of slipped from the just grabbed one person to the 50 people arrested. Maybe I should make that distinction clear. I mean, if you're planning civil disobedience and there are 10 to 50 of you, you better, before you do it, you better raise some money because you're going to need some money. You might find some free help, and Francis does a lot of this for nothing. He's done most of it for nothing.
Harvey's already on call.
Harvey's on call, but 50 people, one attorney, person's trying to make a living, it's not going to work. You're not going to get the kind of defense you need. When the apartheid demonstrators were arrested, there were 6 of us, and they paid us, I think, $2 grand a piece or something.
$125 a person.
125 a person. Well, I'd come up with more like $300 or $400 a person, and plan to spend 70 to 80% of your time just working on the defense. I mean, a lot of your energy is going to go into just keeping the group together, because this defense is going to last for months and months and months. And if it gets up to someplace like Chicago, it may very well be over a year, because part of the strategy is going to make the state spend so much of its resources that it'll yell uncle and give up and let you go, or let you go with some disposition that's agreeable to you. And I'll tie in a loose thread here. Yeah.
I don't want to lose the loose thread, but it also relates to where Jeff, I think, was going on in terms of the university disciplinary system. What happened with the residue from the Latino takeover of the administration building, and how that resulted in the case of Chris Lloyd and others, and how that might fit with your discussion of how it affects a group or a series of groups trying to work through this system.
Yeah, we're way off on something that you're probably not even thinking about. The real potential danger to you is not from the circuit court here, especially if you're not doing anything and you get arrested falsely. It's from the University of Illinois disciplinary system.
So explain this whole process.
Okay. Well, it
This
is without
affects-
explanation.
And this can affect students, undergrad and grad, faculty and staff.
Not faculty and staff. They have other ways they can be disciplined. This would affect undergrad and graduate students. The university has an administrative body that's subject to administrative law that can discipline you. It has a code of student conduct.
Which everybody should get a copy of.
Which everybody should get a copy of. It's too bad. I mean, we can do this again at some point, because this you need to know, and we're not going to be able to do anything but scratch the surface. You really need to know this, because it's what hangs everybody up when it happens. There's a code of conduct that was written after Kent State happened here, and that's the basic code they use and they employ when you get arrested in a demonstration. And basically, it prohibits you. It's so general and so vague, you don't understand what it prohibits you from doing. Consequently, they use it when they don't like what you're doing. All right? No one's ever tested whether that's unconstitutionally vague in violation of your rights to due process or whatever. But that's how it gets used. So if you read it, you'll see what I mean. And it's
You can get copies from.
you can get well, we'll talk about that. That's how we'll segue into that. But I'm not exaggerating now. I'm really not exaggerating. The guys that run it, Dick Justice, before he gets you, and who did other guys?
Screwface is gone now.
Is he gone?
He's retired. I was at a party with him recently.
The guy who's functionally illiterate. This guy could not read. I swear to God, he couldn't read. Because you'd like set a rule to him, and he'd look at it and then ignore it. And I think it was because he couldn't read. He was an old athletic guy.
Yeah, he's a big sports Christian.
So, and he was also a Christian. They're both Christian. He was a Christian. I had a Pakistani client, a graduate student, who was involved in an argument with another Pakistani student at some Pakistani gathering. I guess they were yelling and screaming at each other about their families. Your father and your mother. And this was some kind of cultural dispute. And my guy used some really foul language, and they wanted to kick him out of school for swearing. This is what old Screwface was like. I couldn't believe it. I mean,
His real name was Screwface.
I wanted to, oh, not Scoofus, who's the tall guy?
Doble?
No, God, the middle age, this is what happens here. His brain. Suzanne, do you remember his name? No.
Was he on the Unified?
No, he wasn't. He's in the disciplinary. He's probably still there then. He's Christian, and he didn't like the tone of this guy's language, and he was gonna throw him out of school. I mean, that's what you're dealing with.
We'll go.
In some of the, all right, so
Jump back a little bit.
all right,
So you
they'll
get arrested. You go through all the. Other
they'll
stuff.
give you a notice, all right, that you have to come to a hearing.
This is only if you're arrested on university property, or if you got arrested in downtown Champaign at a protest.
Could happen in downtown Champaign too. Could happen in Chicago. They have authority to
So
discipline
their
you
authority is what?
worldwide. Worldwide.
As long as you're enrolled in university, they
Yeah,
can discipline
they
you
can
for doing
discipline
something anywhere.
That's right. That's
That
right.
nice.
And they'll send you a notice saying you got to be hearing in 48 hours, and they'll send you a description of the procedure, not the procedure. They'll send you a description of the procedure. The description of you have to understand this. The description of the procedure is their interpretation of the procedure. When you read the description of the procedure and the procedure is very different from the description. And there's all kinds of things in it that the description doesn't have. And what they do is, and this is how you successfully defend these cases, they follow the description and not the procedure. So that if you invoke the procedure, they don't know what to do. Because the guy can't read. You cite the procedure to him, and he looks at it, and then he does what the description says. It's bizarre. And that's how we were able to just, and of course they're racist. If you happen to be a person of color, and you can get other people of color in the room, they freak. And that's what Chris Lloyd did. There were probably 100 African-American students who attended
Let him go, give him the stick.
who attended the hearing. They freaked.
But you're jumping.
All right.
So you get this notice.
So you get this notice. And
And they tell you, and they encourage you not to get a lawyer.
They encourage you not to get a lawyer. In fact, this guy, this Christian guy, he wants you to come in and talk to him, right? And he wants you to tell him everything you did. And he's very slick.
This is the head of the disciplinary committee?
No, this is the second guy in charge. Dick Justice is the head of the.
So he wants you, so prior to your actual disciplinary hearing, he wants you to come in and have
Yes.
tea?
Thank you. Yes, he does. He wants you to come in and have tea.
But you could still say, I'm not the same.
Yeah, but I'll warn you, he's
University's
slick.
different though.
He's very, very slick. He's very deceptive. People get suckered by him all the time because he makes you think he's your dad and he's your friend, and he puts his arm around you. He says, you know, I'm here to help you. Tell me what happened. And he takes notes, and then he screws you. He'll have the hearing, and he presents everything you said as evidence against you. So what you need to do is you need to get a lawyer, and you need to go visit him with a lawyer who understands that, and Harvey understands it, as do the right-wing attorneys in town, like Bryan Silverman. Actually would not be a bad lawyer to represent you in a disciplinary. He wouldn't. I know he's repulsive, but he's a very effective lawyer in a situation like that. So you want to go up there, for example, and you want to see what's in your file, and you want copies of everything that's in your file, and you don't want to make. I made a really bad error once, because there was a police report in the file. It was one of the guys in the Latino demonstration. They say that in the police reports they said that he was struggling all the way out of the building, and with the police, you know, and so the university was going to throw him out of school because he was struggling with the police. And of course, the videotape we had of him was walking out of the building with the police. So the police, they lied, right, to set up the prosecution. And when I pointed out, this was the error. I mean, it's stupid. When I pointed out, because I was so angry at this guy, I pointed out the video we had and the lie in the police report. I didn't get a copy of the police report. When I came to hear the police report was gone.
So what happens? So you get arrested, you get a notice, he tries to talk to you, you get a lawyer. I'm just trying to what do people expect? I mean,
Okay.
You
So
get a lawyer.
You get a lawyer.
So
You go up and you visit you go up and visit with him. You don't say anything to him. You make him talk, so he tells you things. You look at your file. You get copies of everything in your file.
You're allowed to.
Yes, you're allowed to do that, and you get a copy of the procedures. Okay, the procedures, not the description of the procedures. And then you if I remember the procedures correctly, you can have a couple people come in your aid. Chris was able at one point, because he was complaining that they wouldn't let people in. They had the hearing in a room with 100 seats or something, so he had 100 people come, and you plan your defense. And the trouble with having a lawyer at these things is that the rule of law is that the lawyer can't say things. The lawyer can't cross-examine witnesses. The lawyer can only advise you. It's like a Senate investigation. It's an administrative body. And the trick is, and actually it was Bryan Silverman who told me this trick, and it just works perfectly. Because this is what will happen. There'll be the chair of the committee who's a Nazi of some sort. And
usually it won't be in front of a lot of people. Usually it'll be in front of their committee.
Yeah, their committee. So you're going to have all kinds of... I don't know anymore.
But what types of people?
Oh, all kinds of Nazis. There'll be little student Nazis, and there'll be staff Nazis and faculty Nazis. And of course, then the director Nazis.
People volunteer to be on the committee. Students volunteer
people
who want to prosecute people.
People who like volunteer to prosecute and discipline people are the people who have volunteered.
Well, what if we get on the committee and then later?
Yeah, that's a good idea. There you go, infiltrate.
Well, that's a lot of work.
So they're on there.
I really want to make sure not to infiltrate, because we care.
The chair of the committee will direct everything, which includes the questioning. So the police officer will come in, and the chair will ask the police officer some questions. And then you have a right to ask the police officer questions, but not directly. This is the trick they play. You have to ask the question through the chair, and then the chair redirects the question to the police officer.
And reinterprets it too.
Yeah, the trouble is, in cross-examining somebody, the strategy, there's two kinds of strategies. One strategy is to show that their memory isn't as great as they want you to think it is, right? So you ask them all kinds of detailed questions about what was the scene like, how far away from the door were you, what color, shirt. When you ask them detailed questions that they can't answer. So all of a sudden they say, I don't remember, I don't remember, I don't remember, I don't remember, I don't remember. Well, maybe you don't remember exactly what you thought you were so sure about in the beginning. Or you try and expose them in some kind of contradiction, a lie. The trouble is that these questions have to be very particular, right? And the chair doesn't care about the particular nature of the question and reinterprets it. So in the beginning, I used to just object out loud, and when they told me to be quiet, I just ignored it and just keep objecting.
That's when you get kicked out.
So they kicked me out. And so the trick that Silverman pulled was to tell the client out loud so the whole committee can hear it. Ask the police officer whether blah 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 blah. And then
with the same question.
Yeah, and then he or she will repeat the question to the chair, and the chair will misinterpret, and then you go, ask the chair, or tell the chair that she screwed up the question. Tell her the real question is, and you say this out loud so everybody's hearing it, so they know what you're saying, and the whole farce is exposed. And
now, what can this committee do to you?
They can throw you out of school.
But what's the range of what they can do?
They can find you innocent, or they can. This is the danger. You don't really know who these people are. They can take you in a back room and give you a talking to, or they can put a letter of recommend. Yeah, they do. Yeah, it is.
What?
Yeah, you just don't know. I mean, you see Dick Justice, you know what it is. They can take you in a room and talk to you, reprimand you, yell at you. They can put a letter of reprimand in your file. They can put you on probation. They can put you on some kind of conditional, I can't remember what the name of the conditional status is, or they can throw you out. They can suspend you, throw you out.
And this is even if you've gone through a civil case and you've been acquitted.
That's right, because this is
they can do whatever they want.
That's right. This is a different level of government.
You could even have, if you're arrested, you could have the charges dropped against you by the state, but still
That's
be
right.
under disciplinary action.
You could be found innocent by a jury trial and get kicked out of school.
How would this affect like state funding and tuition?
I don't know what the law is on that. There was a law passed in the Vietnam era where they could take your money away. So I don't know. Do you know, Joe?
It may only be if you're on some kind of maybe federal aid program. That
Illinois State.
strings tied to that.
That's what I was wondering, like in terms of graduate students who are funded like fellowships and teaching assistantships and stuff like that.
Graduate students is a little different. There's a different committee.
There's a different committee for graduate students
right?
that's a little better.
So it's a different committee totally.
Yeah.
It's
Yeah,
based on
there's
your
a
department, right?
That's right. Actually, yeah, there was some justice in those committees, although the lies had to be exposed. In the anti-apartheid demonstrations, we were able to get the court to enjoin, to issue an order saying that they couldn't hold these hearings. And the way we did that was, it was a nice setup. It was now the fascist Steve Beckett was leading the group of attorneys, and we went into,
he was on our side.
we went into Johnny Screwface's office and suckered him into telling us that it was not to worry. He thought he was doing us great. Don't worry about whether these students are going to be thrown out of school. It's all set. They're all going to get blah, blah, blah. And so we went to the court, and I got on the stand and testified that that's what I heard, and the court enjoined the whole proceeding.
What does that mean?
It issued an order saying you can't do that.
But
Now
they did do a bunch of
Well, then they got a new hearing officer, and
But here's my question, why did you wanted to get it enjoined because?
I want to stop them conducting it.
Because they said, we're just gonna give all the kids this one thing across the board?
Yeah, there was not going to be no determination of whether anybody had actually done it.
Right.
It was all set. It was all, the fix was in. This is what was going to happen to everybody.
And you're supposed to be, they expect you to be satisfied with getting things like probation, they expect you to be happy with not getting kicked out, but with getting punished some other way.
Right.
Well, two things. When I was on conduct probation for a year, which is why I didn't get arrested the second time, because in theory, it was conduct probation, which is different than academic probation. Conduct probation, if you get arrested again in that period of year, they could say you can be kicked out, except unless you're like Rich Dirty and kiss so much ass of a chancellor.
Have your parents come.
But so
Talk to them again.
So that was conduct probation. That's what was happening for a while. The second thing is there was a case. I mean, when we were doing some of this stuff, we were in that office quite a bit. Harvey and you, and Harvey Welch is a lawyer in town who worked with Bryan a lot in the anti-apartheid stuff. Who we approached, and he's very busy. He's got like 3 practices or something, and he's
Public defender in
He
Fort
said he's
County.
awaiting.
yeah. But he's already said that he would help us if need be, if he could fit it in and stuff like that. But what happened? One of these things, there was a party at a house, off-campus house, well, in campus town.
Oh, that's right.
There was a party in some apartment building. No, this was even later. This was much later. African American students. Someone goes upstairs and kicks the door open. These guys were all friends, and they get into a fight. And then they get arrested, but no one got hurt. Nothing happened. These guys show up without lawyers. They're talked to by this guy, the Christian, and they show up. And then within 10 minutes, they were expelled.
Yeah, they were
fucking expelled.
I think they were, because we had just won, right? They had just
won.
given up on us.
With the CIA stuff, we won.
And they were upset because we threatened to sue them, and I mean, the students were, one of them was in tears.
Well, Harvey saved one of them, but he didn't save all 3 of them. So he went down and worked on it. But that's what happened without a lawyer. They told them all these things. It's okay. Don't worry about it. You don't need a lawyer. You don't need a lawyer. We're like, you guys need a lawyer. And it was a party. It was
Yeah, they kicked them out. Yeah, don't underestimate how much, not only how much work this will be for you, but how depressing it's going to be, how much it will take a toll on your studies and so on. Because one of probably the most successful strategy in defending these things is not to present a rational argument that you didn't break the rule, although you can do that. The strategy is to keep them from conducting the hearing. And you do that, of course, by invoking the procedures that they haven't read with a lawyer, and having the lawyer, threaten to do this, that, and the other thing, and getting enough public support so that it becomes an issue that they're embarrassed about.
That was one of the things with Chris Lloyd's case. He kept that up.
Let's explain who Chris Lloyd is.
Just a second, but he kept, more and more people kept showing up in the hearings, and they kept having to postpone it.
Yeah.
And then there was all the issue with the media outside in the hallway and interviewing people outside. So that was successful in a way of putting that aside.
One of this will just give you a background.
Explain what Chris Lloyd was.
Chris Lloyd was an African-American student who was involved in the Latino demonstration. They had occupied the administration building probably half an hour before it was going to close, and they wouldn't leave when it closed. So ultimately, the police, there were a bunch of people outside, and when this happens, they have protocols where all the different police departments in the area come together. So it's the U of I police, the Champaign police, the Urbana police, the state police, and the county police. And you can imagine when all these police agencies are together that they don't really have a good idea how to work together. So you got people acting on their own.
They had stun guns.
People taking off their badges, stun guns, and they're in riot gear, and they got guns and gas in their cars, and they're ready. And so Chris was outside and probably rushed the police at some point, although it wasn't real clear. And he gets arrested, and there were three of us. There was Harvey and I and Francis, and we would go to these hearings, and we wouldn't let them proceed unless they complied literally with the procedures, and they couldn't because they had and so they would keep having to reschedule the hearing, and more people kept coming, and we would make complaints about the makeup of the hearing committee, that there were all these white people, and this was a black guy, right? And so this will show you what they're like. So they bring a black guy to be on the committee, and he's blind. He's blind. And the principal piece of evidence is a video.
You're kidding. Wow.
I mean, they're just really, what's going on? And of course, that committee got that never happened. And so finally, they were so desperate, right? They must have had some real high-level meeting, and they got an African-American professor to chair the committee, and he talked to Chris. They struck some kind of deal, and the hearings went on.
Were you at that?
I was there.
So whoever that professor was.
That was bizarre.
Well, just for the sake of time,
Yeah.
I don't know if people have more questions about the disciplinary stuff right now. What I was going to suggest, well, one, I wanted to throw like a little side thing, ask about the whole concept of Miranda rights, because that's very misinterpreted. To do that, and then maybe to segue into documentation of things.
Okay, we can wrap it up real quickly. Miranda versus Arizona or something or other.
This is the thing where people
again,
see on TV all the time.
Yeah, this is common sense. This is, you have right to remain silent, right to representative, anything that says you use against you. Miranda is virtually worthless. It's the police are required to read you the Miranda warnings when they're engaging in a custodial interrogation. That's when Miranda becomes operative. Custodial interrogation does not necessarily mean an interrogation in the police department. It could be an interrogation in your home. It could be in a car. It could be in the street. It's an interrogation that takes place when you are not free to leave. Okay, and before they conduct that kind of interrogation, they have to read you those rights. And suppose they conduct a custodial interrogation, and they don't read you the rights. What's the consequence? Nothing, really. The only potential consequence is that if, as a result of the interrogation, you say something that they want to use against you, or you say something that leads to another piece of evidence that they want to use against you, you can ask the court to suppress it. But there are all kinds, so there's the suppression rules, but you might recall public discussions about suppression being unfair to the police and to what we really want to accomplish with the criminal law, because all these criminals are getting off because the police make some error and they go out and commit more crimes. And there's some truth to that, but the point is that as a result of that public pressure, there are so many exceptions to the failure to read Miranda that Miranda has been gutted. In the same way that the Fourth Amendment has been gutted when you're driving a car. So
you get arrested, and they arrest you, put you in the car, and don't say anything.
And you say something, you screwed up. If they don't read you your rights and they engage you in conversation, and you say something that can be used against you, and they use it in a trial, you can ask the court to suppress it in order that it can't be used.
What if you say, "Why was I arrested?" Should you ask that question?
You didn't know. You shouldn't say anything. Nothing. Absolutely nothing. If you need medical help, you should tell them that, but tell them nothing other than what they need to book. Nothing. As innocent as don't say anything. because they'll lie about what you said, and you don't really understand what can be used against you. Stuff that seems completely innocent can be used against you. That you knew somebody. Who else was there? Well, so-and-so was there. They may have so-and-so dead in the water. Now you've said you know so-and-so. So they're connecting you with so-and-so. That's evidence against you. And it ties you into what so-and-so did. Don't say anything. Nothing, except what they need to look at. It's a hard and fast rule. It has few exceptions. If you need medical help, tell them you need medical help. Cooperate with them. Don't resist them. Cooperate with them.
So maybe before we segue into that, if we're doing a planned arrest, what should we have on our persons? What should we not have?
Don't have any drugs, prescription or not. Don't have any weapons. Oh God, don't have a pocket knife. Don't have anything that could be construed as a weapon. I wouldn't have a cigarette package on you. I wouldn't have much of anything.
Why?
Well, because they have a right to pat you down. And if they pat you down and they feel something which they interpret to be a weapon, they're not going to keep. You're going to be flat on your face on the ground. It's not. They're going to apply force to you. And if you have something like a cigarette pack, I wouldn't put it behind them to put drugs in it. I mean, you have to understand. And I'm not saying I've ever encountered that in Champaign County, but it does happen. The police do those kinds of things. A lot of them are corrupt. Some of them sell drugs in the Austin district of Chicago. They had ties with the FBI during the Gulf War. The police are the police. And the drug cops here are corrupt. We all know that. The courts even know it. And so don't have anything, maybe an ID.
What about money?
Yeah, probably have a little money. Probably have a little money because you probably need a little money in jail. They keep you in jail.
What about buttons or?
No, I wouldn't have buttons. Oh, that raises an interesting question. You should have signs or leaflets or T-shirts with information on them that will allow you to raise certain types of defenses. In other words, if you are planning an arrest and you want to raise an international necessity defense vis-a-vis Francis, you might want to have literature or something on your T-shirt that invokes a human rights law, Nuremberg, or whatever it is you're protesting, the International Compact Against Racism. I don't remember the names of the conventions. If you're going to go to the Ku Klux Klan, you might have something that I don't blame you. You might have something that invokes that. See, because you've got to have some edge to get it in. But that's another time. So let's talk. I know everybody's getting tired, so am I. Let's talk briefly about FOIA because it's a great weapon, and you can make them absolutely crazy and paranoid with this. Plus, get a lot of good information. And if you look through the files that we do have, a lot of the information was obtained through FOIA. FOIA is the Freedom of Information Act. It's at verse 5, chapter 5, volume 5 of the Illinois Compiled Statutes, chapter 140, section 1, and the sections following. And if you want to read about it, actually I brought it here. I'll leave it here. I want to retrieve this book, but I'll leave it here. I'll leave the statute here. And some of you may be interested in law school. Some of you aren't, but you might want to, if you're going to engage in this kind of activity, if this is a matter of principle to you, and this is, where your life's going to lead you for a long time, you might want to start to learn how to read a statute. And you can take a look at the Freedom of Information statute. And it's almost common sense. It's almost what you think it is. And in the beginning, there was applause. There's always a section that expresses the public policy, the intent of the legislature. Well, all these people were talking about listening to each other. They formed some kind of common intent. And it's pursuant to the fundamental philosophy of the American constitutional form of government. It is declared to be the public policy of the state of Illinois that all persons are entitled to full and complete information regarding the affairs of government and the official acts and policies of those who represent them as public officials and public employees, consistent with the terms of this act. And then you read the rest of the act, and it's full of restrictions about what you can get. So this is cover for them keeping certain information from you. You have to understand that in the beginning. But it does set out a bunch of categories of information that you can get from them, and it sets out a procedure for doing that. And every public facility, every public institution, every public form of government, except maybe the Champaign County, because it's run by some guy who doesn't give one shit about this statute, that has to have an officer in place that handles public freedom of information requests. And who is it now?
It's not Judy Roan because she got bumped up.
It used to be Judy Roan, all right? And whoever it is probably the same type of person as Judy Roan. She's like the minister of disinformation. She authors all the public statements that try and spin the way the university looks in the public eye. And she controls the access to documents. So you would go up to her office, and she has a form up there if you want to use the form. And it's on the 3rd floor, I think, of the new Swanland Administration Building, so on the southeast corner of John and 6th. Go up to the 3rd floor, get off the elevator,
What's the office?
turn right. The Office of Public Information, the Office of Public Relations, the Gestapo. What would it be? The Ministry of Disinformation. She has a form up there, but don't use her form. All you have to do, and here, so that this is advice you can use. All you have to do, we'll author a letter, and then we can send it out and see what happens. All you have to do is kind of recite a litany of terms.
Why are we doing this, though? What's the problem?
Oh, to get information about Illini WAC. Not only that, to get information about what they think about you and your activities, because you know you've caused them to write all kinds of memos. You know that's what they do. They write memos back, and I mean, I'm not saying that to be funny. I say that because that's what I get when I make these requests. They write memos back and forth. Oh, he did this, she did that. You know, we better send the police out here. We better do that. You know, oh God, we've lost the eagle feather. All kinds of
stuff.
What's
some examples of some of the stuff that we got that was useful?
Okay, well, it's in your files, right? So you can read it. We got all the stuff about the eagle feathers. This is potentially, no one's ever followed this up. I did not follow this up.
What's the issue in that?
Okay, at a certain point, it was unlawful for the university to possess an eagle feather without having a permit to do that. And even for the eagle feathers they had permits for, I think every year they had to report to the government about whether they had them and where they were. And in this memo...
It used to be an eagle feather headdress, but they changed that.
Yeah, they had several eagle feather headdresses. And in this memo, Michael Haney had come to visit. And Steve Beasy, associate counsel, lying son of a bitch, scum of the earth. This guy has no principle at all. Fuck you, Beasy. Excuse me. No, he is a liar. He's got no principle at all. And there will be other counsel in town that will say the same thing about it. Steve Beasy gets all freaked out, right? Because they've lost track of some of the eagle feathers. And they don't know whether they were subject to the law or grandfathered in or whatever. So this actually would be an interesting issue to take up with the federal government about where these feathers are, because I have a feeling that they found them and they had to give them back. This is a criminal offense. They could have been in criminal trouble because of this, and nobody really followed it up. So that's one thing you could do, and I think we copied the statute that that covers it. So let me read you a little bit. I recently had a visit with Michael Haney, a representative of the United Nations Indians in Oklahoma. Now then they whited part of it out. I write because of two potential legal weapons Haney mentioned. Right? He asked him to write some memos. It's obviously important that we make sure we are not in violation of any laws. And then they go on to explain the eagle feather trouble.
Well, the stuff that's in Jay's film, the Redskin tradition stuff.
That came out of a Freedom of Information request that I made. Gary Smith, the director of the Marching Illini, used to be the keeper of Illini WAC. And apparently for basketball and football, they had the official story of Illini WAC that they'd hand out. And of course it was just, and it's attached here, and it was full of blatantly racist descriptions, this, redskin tradition, the frenzied Indian, stereotype, frenzied Indian dance. And this was after Haney and Charlene had raised a ruckus. And Gary Shepard, who I think thought of himself as a person of principle, was put in charge by another man of no principle, the former Chancellor, Morton Berdahl. I used to get, the two of them used to merge. He says, as the Chancellor's designated hitter on Indian questions, I am in need of help. I received a copy of the two-page chief alignment with tradition sheet handed out last week to applicants in the chief. It's probably been years since anyone reviewed this, and there's a number of shortcomings we should fix on grounds of both accuracy and sensitivity. Right, so this is where they say it's an accurate Indian tradition, an accurate drum beat, it's authentic, and here they are. That's what they're representing to the public. At the same time this memo is written, Morton Weir is making public statements that it's authentic, that it's respectful, that it's a long tradition of respect. And in this memo they're saying, I better stop calling it the Redskin tradition. Boom, 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 boom is probably a Hollywood drum beat, it's not authentic. To themselves, they know what's going on. They know it's racist. They know it's not authentic. They know it's harmful. They say so when they think they're talking privately, but they won't say it publicly. So you can get a hold of this stuff. And I don't think I can put my fingers on them because I don't know exactly where they are.
Well, can't they just not give you stuff? Can't you just say, I want this stuff, and they'll say,
well,
I
asked myself that same question. Why did I get this stuff? Some of it I surely got as a mistake because they were legal memos and they were confidential. And it's either because somebody gathering the records was on our side, or the request was so huge that they lost track of what they were giving me and what they weren't. They lost track. I asked for, you could use this as an example. I asked for, what you have to do is you have to identify the records, the period of time during which you think they were written, and who's going to be in control of them. So I said, for the period between May 1989 and the present, which was 7/18/90, any and all correspondence, memos, notes, directives, or the like, between and among any of the following individuals and departments regarding the status or subject of the use of the chief as a mascot, and all protests, objections regarding the same, in the possession of, and then I just started naming people: Stanley Eichenberg, who was the president, Office of U.I. President, Morton Weir, Office of the Chancellor, Judy Rowan, Robert Berdahl, Stan Levy, Terry Shepard, Gary Smith. Just name all these people, and then they've got to go look through their files. So, look what you're doing. You are making them undertake an incredibly difficult search for records. You are using up their resources in a way they don't want to use them. And you're making them give you stuff that they're going to find embarrassing. Because part of what's going to come out of this, and what came out of it before, was the police being notified about these demonstrations. Set up the cameras here, set up the cameras there. The stuff I didn't Xerox that I could kill myself for not doing this, I made another one for around the economics of the chief. So I wanted to know all the images that were trademarked. To know the money they were getting for it, and who held the trademark, and who was getting the money, and where they kept the money, and who authorized it. About this, they supposedly have some committee that talks to campus merchants. So what they were doing, and this would be great to try. What they were doing was, and the reason I didn't copy this was, they were charging 25 cents a sheet to copy this stuff.
They get them, so you submit the letter, they look for it, they come back with some stuff, they let you look at it, but they charge you for it.
Yeah, so it got real expensive. Well, under the statute, if you say in your request that this is a matter in the public interest, they're not supposed to charge you. And I would say that, and they would deny that it was a matter in the public interest. So, of course, if I were them, I would do that too. And then the burden was on me to sue them. And it was always a burden that was too difficult to do at that point, because there was so much else going on.
Let me pass around. This is in the anti-CIA stuff. Here's a sample people can look at. All of this stuff here we filed, and we got contracts. There were two CIA contracts at the time, and we got all of this stuff and all of this through a variety of, and we had to file for a bunch of stuff, so people can just look. That's kind of a form. It's a different issue, but it's a similar kind of things that you'd be asking for. Because you have to go from broad to specific, right?
Yeah, you want to be specific. If the request is too broad, they'll call you up and ask you to narrow it. If it's too burdensome, they might deny it on its face. If there's all kinds of things you're not entitled to. For example, when we asked for the CIA stuff, we asked for contracts and proposals for contracts. Proposals for contracts are specifically excluded as something you can get. So we got contracts but no proposals. We knew who would have the contracts but not who wanted them. They have 7 working days. They have to produce the stuff within 7 working days. Then if it's a big request, they can automatically get a 7 working day extension. If they exclude a category of the request, they've got to give you a reason why they're excluding it. You can appeal to the president of the university. If he denies it, you can sue in the circuit court.
So, and what about the government? What's the difference between this and the government one?
What government?
If you want to find out something that's not within the university, what's that for?
Oh, there's a federal procedure that I'm not familiar with, but you can do it through the federal government. This procedure will...
That's on the web.
It's on the web? This stuff will get you useful information. It will get you useful information at very little cost to you in terms of money and energy, and it will get you information at a very high cost to them. And it will allow you to see what they're thinking about you, how they're following you, how they're keeping track of what you do, and if there is someone in there who likes you, or they just can't keep track of the request, you'll get very damaging information. This information that I referred to served as the basis for the complaint we made for Haney in the Illinois Department of Non-Human Rights.
So you're going to write one for us on the board?
Oh man, it'd probably be better to hack one out on a PC. So maybe before I leave, we'll hack one out.
Okay.
Well, I mean, the statute gives you the hint about how to do it. Basically, it's any documents, but a document is a legal term, so it has a definition that is not commonsensical. A document means a memo, a contract, a phone diary, a tape recording, a picture, a sound recording. You can get all of that stuff. So we actually got pictures the police had taken. There was, 2 minutes of video that I didn't pay to get a copy of from the protests at the stadium that Charlene was holding. And the one thing we didn't talk about, just talk about it very briefly, is if you want to protect yourself from, and I know you have security training, you probably hear this in security training, but I really think it paid off. If you want to protect yourself from the police and from crazy right-wing people who would start a fight with you, have still cameras, video cameras, and tape recorders, and people to float with them. So anytime the police comes up and starts talking to one of you, the camera and the recorder is there, and you let the police officer know that. And the crazy right-wing person, you snap that person's picture many times. And that, when I used that trick in the stadium, when I used to go to some football games and go bananas when the chief would yell and scream and curse, and people, like Francis said, people would throw stuff at him, right? And people would threaten me, and I mean really threaten me, and I would start taking their picture, and they'd back off. The Shell demonstrations on Shell apartheid demonstrations at University Avenue, the police would come and say we couldn't be on the sidewalk, and we'd bring the camera up to them, and why not? Why not?
Public.
Yeah. And so they'd back off. They better know they're being filmed.
And Adam, this is the thing that you told us a long time ago. One of the things that we should carry if there might be arrested is pen and paper. If somebody else gets arrested, to try and recreate if you get arrested or someone else gets arrested, try and recreate every detail you can remember right away.
Write your memories down right away.
Because the longer it goes, the more likely you are to forget or to hear somebody else tell a story, then all of a sudden something else. Not just about you, but to write everything down.
And other people have cameras. Put an ad in the DI to see who else has film of this stuff. During one of the Cash Wednesday demonstrations when there were 6 arrests, I had I defended a second guy who was arrested. He was surely stoned. He'd been surely smoking dope. He'd been arguing with the police all day long. At the time of his arrest, he was eating a brownie. He probably had cotton mouth. The guy couldn't even, like, just chewing on a brownie. And the police in their reports, 4 separate police reports, all 4 of them saying exactly the same thing. You know, that he resisted them and that he brushed against them as though he were going to grab their gun. Oh, God, this guy was dead. They wanted him so bad.
Is that Eric?
No, I can't remember this guy's name. And so he, you know, I told him, you know, you need to put an ad in the paper and find the videotape. Somebody came up with a videotape that showed him arguing earlier in the day with the police officer who arrested him, and chewing on this brownie at the time of his arrest, them grabbing him from behind. He didn't know who they were, right? And he doesn't struggle at all. I mean, this guy is trying to swallow a brownie. He did not struggle at all, and showed this tape to the state like a day before the trial, and they dismissed the charges.
Because he was on trial for resisting arrest?
No, they were going to send him to jail.
But, and so all these files are in the PRC office in that file cabinet in the back. And there's a whole bunch of stuff. Here's actually some police reports from when Belton Fields got arrested.
Oh, God, Belton, who asked about holding the sign up in the union? Did you?
Me. Political science professor had a sign this big that said CI off campus name. That was after they arrested us the day before.
You know what the safest way of holding a sign up in the union is to put it on T-shirts, and if it's too long for one T-shirt, just line up so people can read you. It really does. T-shirts are protected forms of speech.
But a piece of paper.
Well, they can make a rule against a sign because it's like picketing.
Well, they tried to say it was picketing.
Yeah, they tried to say it was picketing, but they can't make a rule against a T-shirt.
But they're freaking Republicans, they're picketing, that's what they were doing.
You gotta.
We should never use the word picket, though. We never want to use the word picket, right, Brian?
Right. Yeah.
We shouldn't say we're picketing.
The law on picketing is bad.
Why?
Not picketing, because they
It just
outlaw
doesn't protect it in public buildings.
Protesting isn't picketing.
There's a whole body of law on picketing.
Is it a semantic thing, basically? Is it?
Well, it's a semantic thing with consequences. I mean, yeah, it's semantic. They're going to call it one thing, you're going to call it another.
Okay.
But
There's also this weird thing about the Courtyard Cafe, in that they have like private management
Really?
set up, so that you can't go through the Atlanta Union to go to Courtyard Cafe, you have to go through their separate management. And so when these people show up with signs, you know, that's a whole different level. Because we had, like, how we had a big setup last fall, because we had to deal with the specific person who was set up within the union system, but you didn't just book the room like you'd book any other room in the union. So you would select, you want to book the South Mount, you want to book the room in the union. You didn't use that system, you had to use a special system to get to their cafe, which threw us for a while.
God, I wonder what that's all about.
It was pretty clearly a way of just controlling.
Well, Joe, that brings up interesting things too, because they're outsourcing so much. I mean, you know, the union, in theory, I mean, one of the things we tried to use was that the union is a student union. We tried to use this, you know, years ago, and that actually students have a right to be in there. So it's not, it's private, huh?
Students.
But now they have all those in the basement. They're setting up like McDonald's and everything. So now it's not even a union anymore. I mean, how does that, you know, they have that within their own space. So that probably be.
Because that's private property.
About the malls. Right.
Yeah.
About the malls. It was recently, I don't know if I still see it, there was a case, I think it was in Minnesota, a case that was recently won by protesters that actually got a mall to be
Semi-public, at least.
it was considered semi-public because it was a question of how much public funds were used
Oh, it's
in
expensive.
the maintenance or in the building.
Oh, yeah, do you remember that? Was it for the CIA? Beckett was trying to figure out, who was trying to figure out how much money was spent on cutting
It was
the
for the-
shrubs?
It was for the
Remember?
U of I. It
The
was
issue
for
was,
the-
the issue was whether it was
for the
state
apartheid
supported.
because the big question was,
State supported.
we were charged with trespassing on state-supported land.
That's right.
And and the issue around that was, okay, if this is, I can't even describe it. You know what I'm talking about.
Yeah, well, I have a vague memory of it. I mean, you have as good a memory as I do.
But the question, the issue was that if this is state-supported land and we are paying state taxes, then it's our land. And how are we trespassing on it? It is a public, like the building was about the union. The union is on state-supported land. The union is a part of the university, which is a state-supported institution. So how can it be a private thing, and how can you be trespassing on state-supported land?
My memory, I remember the issue. My memory isn't that we use it for that reason. My memory is that the punishment for trespassing on state-supported land was harsher than for trespassing on private land.
Right.
And so Beckett was trying to figure out if there was enough money into the maintenance of the union to make it private. So we were wondering about the shrubs, something like that. Something really weird.
Well, as we wrap up and wind down, anybody have any questions that didn't get covered? Clarification about things Bryan has said?
Can I say some other things while the camera's rolling?
Wait, is this relevant to that, or is this just?
He's got a camera, he can't help it.
Let's have the questions first.
Okay. Second is a pig.
It's true.
This is sort of related, but you didn't cover anything about that. Talking to the BOT, so like Rose did, if they take the request, I'll be there too. And I was wondering about slander, and if, like, I compare them to Marge Schott and give examples of her racist speech. Is that?
You're not gonna get in trouble for
Why
that.
not?
The last thing in the world I would think they would do is sue somebody for slander, and the reason is, if you got sued for slander, you would have to defend yourself, and in the process of defending yourself, you would have broad discovery rights, broad subpoena powers to get at their private files. In fact, it would be a blessing if they sued somebody. We would find so much information that would be damaging. We would find the papers where they really say they know what's going on. I mean, it would be. I mean, of course, it wouldn't be a blessing for the defendant, but it would be. You're not going to get sued for slander. If you want, but a more educational answer to your question is that slander and libel are forms of defamation. And defamation is a legal category about statements. So a statement is defamatory when it is false and tends to hold the person it's made about in disrepute in the community where that person lives. So for a statement to be defamatory, it must be false. So true statements are protected. And it must tend to hold a person in disrespect. So what you say about them has to invoke public criticism against them. And not only that, it's got to be damaging to them. You can slander somebody and cause them no damage, and they can sue to have a court stop you from saying stuff, but not for money. You have to show damage. Slander suits are very difficult. And if the issue is one of public debate, you have to, even if it's slanderous, if you didn't make it in reckless disregard of the truth, then it's not even actionable. That's why newspapers can say the stuff they say. Because if they're talking about public issues, then unless they're in reckless disregard of the truth, they can say almost anything. So don't worry about it. That's why I can say Steigman is a pig, because he is. He's just like Marshall is worse. Steigman on Jim Turpin's show, this is a guy you'd think would understand differently, right? Because he's Jewish, and he understands the Holocaust. He understands the terrible genocide that can be worked against the people. And he was there apologizing for American history. Oh, I don't think it was genocide what we did to the Indians. And besides, this is what every country makes mistakes, and we have to get beyond it. This was in response to. This was somebody sitting on the appellate court.
Is that the guy that was walking around here?
Yeah, this is when we were having a protest, a chief protest, and we were protesting the marching band as they went from the armory to the stadium. And I was running backwards with a camera, trying to talk to Gary Smith, asking him what Oskiwawa meant, and whether that was an Indian term. Steigman ran up from the background with a can of beer. He's an appellate court judge running down the street with a can of beer in his hand, right? Because this is a drunk. This is all about alcohol, and you know all the lawyers and the judges and the bankers and the bakers are all out there, right? And he's running down the street with a can of beer in his hand, criticizing me for being politically correct.
Anybody ever figure out what that meant? Because I saw a lady at work one day with a shirt that said Oskiwawa or something like that on it.
These are made up words that the university made up.
It's an Indian term.
Oskiwawa and Ungawa, they say they sound Indian, so they use them.
Yeah, the band says Ungawa as he comes out.
Oh, the band says it?
Yeah.
Ungawa was published in the Observer on that big old thingy. They like stuck it in there somewhere.
So use FOIA. Boy, if there's anything you get out of this afternoon, use FOIA. I'll write a couple FOIA requests. How about if I write a couple FOIA requests? I'll send them to Jeff, and he can show them to you. And then you monitor the production of the documents over there. Because I'm in Chicago, I won't be able to do it. But you monitor the production of the documents. And then you can see how easy it is, and then you can do it. That sound okay?
Now, what kind of things would we want to know about recently?
Well, you'll have to tell me the
What their
activities.
response to Indu's honor show.
Yeah, well, and
Their response to the talking point.
yeah, and your Rose, and you spoke to the bot. All right, so we'll ask a response to bot, to Rose, and if any of the bot members wrote anything down about it. If there are any pictures, we'll see if they were in there snapping your picture. If there's any police reports or anything like that.
You asked them about when they had the police go to the DOT thing and brought all that stuff to their lunch or whatever it was?
Sure.
And they had like 12 officers or something like that.
You might want to do it right now. You have to tell me what you did and approximately when it happened so I can describe it in the letter. So somebody might want to write that stuff down. You can see them. You ought to write these things in response to events that you hold.
Is there a time frame? Like, can we go back? How many years can we go back?
As long as you want.
Did we ever get anything out of the cheap trials?
We never did an FOIA yet.
So was that guy you were yelling at all the time? The handler. Having a bad day in the office on Monday, I bet.
Oh, yeah, the zookeeper.
Yeah.
The chief is an animal.
Any other questions? Final.
What about like you know, your objective scenarios? We kind of went through, but like if we were leaving a bird proceeding and started changing, what would that be?
That's potentially dangerous. That's potentially dangerous. And what effect? You gotta, balance the effectiveness of what you're doing and the danger that you're raising. I would think you'd be better off doing something like the buoying I talked about, or what did we do during the Gulf War when those generals were here talking about the next time? Everybody set their watches to go off at the same time. How are they going to know it's your watch? I mean, and who was sitting in there with a big penis nose on?
What?
Bridgeford went in with a big penis on her nose. They were dicks, right?
She's like this mid-60s Unitarian. So sweet.
That's right. Yeah, and then people would be moving around in their chairs, and then everybody's watch would go off. Or you could. I think bringing those masks in is okay. That's more potent than chanting.
Well, a few things have changed significantly since we've done stuff, or since things have happened. One, Latino protests happened, and since then there's not been any political arrests since then, and that I think changed a lot of things. And Doble and Dollins are both gone. These were pigs who were in university cops for like 20 years, and they were the ones who were breaking up the protests in the 60s and the 70s, and they had all this experience of breaking up big demonstrations, and they're both gone now. And then the last thing is three things. Oh, GEO. Right now, GEO is actually doing a lot of stuff with these board meetings, and they're pushing things. They're involved in this whole union thing. They're very organized. They're in there with signs. They all had, I mean, there was signs at that last meeting. Big signs. They all had big signs. There's pictures. Show the pictures.
God, you gotta
So,
take pictures.
and see, GEO, what they're afraid of is organization. And they're afraid, GEO is now affiliated with FLCIO. And they know that there's a lot of organization and support behind it. So I think these things are changing somewhat what we're going to be allowed to do.
They chanted.
They brought a dog in too.
Somebody,
That was a great one.
That's in the Board of Trustees meeting?
yeah, somebody.
Oh my God, no, but I mean,
After somebody from GEO talked, we were all clapping and the GEO started chanting really loud. I mean, just while we were clapping, and we did it longer.
See, the defense there would be, you look at the Illinois legislature, look at the parliament, they can conduct business with a little noise. I mean, that's part of debate, even in a legislature, is booing. And so that, and to make one final effort to retrieve Francis's reputation. After the Latino demo, Morton Weir lost his job, Levy lost his job.
These are the chancellor and vice chancellor.
Doble and Dollins lost their jobs as a result of a political agreement that was made after Francis organized enough political power to have a member of the Illinois House and a member of the Illinois Senate come and hold public hearings about police conduct and about administrative conduct. And there it was. You had the chancellor and the president of the university sitting at a table together, blaming each other for what happened.
I have a question regarding like those pictures and stuff. Now, we do have pictures of signs being used in the union, like by the anti-chief people, and they're signing the board trustees meeting. What do we do? Like, is that only once you're arrested for having signs? Like, if they tell us
Yeah.
it's not an anti-chief, then
That you can't have them. What you claim is that they're censoring your speech because they allow other groups to have them, and there's the proof.
and what about keeping people out of the board trustees meeting? In the past, that people not been allowed, like more than several students to come in or whatever, or they've been have asked people to leave. Can they do that to you?
Well, not lawfully, but that's not even the concern, because the concern is to get in. And even if they're doing something unlawful, you really don't, I mean, you can't run over to the court and get an injunction, which would be your only remedy. So the real, if you think they're going to do that, the real trick is just to go in separately, you know, just to get in there,
Like an idea of going in there and then like putting on blackface or something, like changing once you get in there in front of them.
You can see, I think you can do this. Non-disruptive speech is permissible. So you could go in there with blackface. You can go, that's why you can hold those signs up, or those
As
faces.
long as there's no sticks, we shouldn't use sticks because they could use those as weapons.
Yeah.
That's what they used to say.
Yeah,
They used to
I
say
know.
that. Well, one thing that we did do in the anti-apartheid stuff, after they'd arrested people, I think, or maybe when they wouldn't listen to us after some vote, we went in there bound and gagged, or we showed up in there, we tied our hands and we gagged ourselves, and we had like 15 people sitting right in the front rows, bound and gagged, until we got bored, and about half an hour later we had to leave. But we sat there for a while, and it was a good photo opportunity, and it pissed them off, you know.
Although, I mean, I think with the fact that you've been able to talk to them, I was just shocked when I read that. I was amazed.
I went in there to the board of trustees office, like they could be right into Michelle Thompson's office, like they shook my hand and were like, oh come on, man, like, right? So, yeah, they were like right away. They're like, oh, we're gonna call Susan today. You guys have a job.
it's amazing.
Can we, I mean, can,
It's absolutely amazing.
could we even ask for memos, like, what they're thinking about this whole issue? I mean, we've heard, what was the rumor that, well, we've heard that one.
Well, one of the
before, so-
rumors was that there's somebody inside the president's office that we
Right.
apparently heard about,
Yeah.
that is favorable to the anti-Chief movement and has communicated to one of our members that it's gotten so bad that the anti-Chief issue is a priority issue. And they had to come up, they felt they had to come up with 10 good arguments, 10 good
Right.
arguments in support of the chief. And all of
That'd
the
be a good memo to get.
and the people who came up with them don't even believe that they're any good. So now Stucco is being prepped with these 10 statements. It would be useful, I think, if we could ask for that specific.
Yeah,
Be useful
sure
what
we
those 10 statements are. And the people who actually put them together don't believe that there's any strength in any of these statements. So this person is, we don't know who it is. The person you heard it from recognizes this person. So there's people inside various offices who are open to what's going on. And we did hear the thing, 3 to 5 years
actually, another unrelated thing that came up last week. We have an infiltrator in our group.
Yeah, I saw
At our
that.
meeting.
We don't know for sure.
I know, I'm saying a
So what
scenario.
happens?
We have an infiltrator in our group, or we think we have somebody from the college Republicans in our meetings.
I work for the commission.
What do we, no, what can we do? What can we not do? Legally.
Oh, you can keep people out of your meetings. If you want to have core meetings where you know who the people are that are there, you can keep people out.
What about at a publicly announced general meeting, which we have once a week? Could we?
Well,
we
no,
could
if you're inviting the public in, no, actually, you could, if you thought somebody was there, if you made an open invitation to the public, come to our meeting, and you thought that a particular person there was an infiltrator, you could tell the person to leave. And if, tell them you're gonna call the police, then call the police.
And what, on what?
It's trespass. It's a private institution.
But
They're no longer
we
welcome.
invited the public.
That's okay. It's all right because you're a private group. It's the same thing like a shopping center. You know, merchants, the law will say that merchants extend a general invitation to the public to come and do business with them. And the public comes and does business with them. But if the merchant doesn't like you in the merchant's store, the merchant will tell you to go. And if you don't go, the merchant will call the police, and the police will arrest you for trespassing. Now, if the merchant, go ahead.
Sorry,
No, please.
I was just gonna say, but doesn't there have to be something behind that? Like, you can't say, you know, I don't like you as a merchant. I don't want this person shopping in my store because they're African American or because they're gay
right.
or whatever. And can this person?
Well, there are forbidden reasons. There are forbidden reasons, and racial, ethnic,
Okay.
etc.
But if an infiltrator says,
Well, they're gonna say
say I'm a student at the university, or I can stay here if I, you know,
But-
it's a public
But
meeting.
but
another
it's-
issue, Brian, just because we're dealing with registered student organizations, wouldn't that be a problem if registered student
Well, that's-
organizations were asking people to leave their meetings?
That's a good thought, and the way to answer that question, I mean, that's a good question, and it deserves an accurate answer, and the way to answer, which I don't have, and the way, well, because the way to answer it would be to look at the rules and regs for registered student organizations. But don't